standpoint as well. So I think Andreas can have a little speech, and then we're going to a little bit more of a workshop session with some of his colleagues. Thank you so much. Let's welcome Andreas to the stage.
Okay, wonderful. Thank you. It's going to be a bit of an experiment now, because the idea is to move away from this classical panel discussions in more of a kind of a elementary school level. So what we're going to do, we're going to focus, as announced, on the question that was raised in the initial panel today. At what point in time is a DeFi protocol sufficiently decentralized? And the concept there is essentially, as of now, I think in most jurisdictions, if something is sufficiently decentralized, fully decentralized, whatever that means, I think we need to explore that today, then we still fall outside the scope of regulations, at least in some of those roles. And how we want to approach that is basically with a three-step approach, and I'll be giving an intro on that, and then we'll, and please join me, Thomas and Ronald, having a discussion on those various elements. Thomas Nageli will join as well. I think he's a bit late. Oh, come. Wonderful. You guys, maybe just by way of introduction, you want to introduce yourself quickly again?
Yeah, Thomas Linder, tax partner at MME.
Introduction. Yes, so maybe you've seen me before. My name is Ronald. I'm a partner at MME in Web3. Happy to participate here.
Thomas Nageli, a lawyer from Liechtenstein.
Okay, wonderful. Maybe one thing, as we said, it's going to be a bit of an elementary school feeling, so you can ask questions anytime. You don't need to wait for the very end. I think whenever you have something to say, please do that and ask that. Essentially, when we look at how we in our daily business approach this question, is a project which approaches us sufficiently decentralized? We basically do it in 3 steps. And first step is to kind of get an understanding on the general risk framework of a DeFi protocol. So what are the risks involved? What is the likelihood that regulations are being triggered? The second step would be then to kind of boil that down to the different roles that are related and how the protocol works, and then to kind of apply, now in our case, Swiss regulations, in Thomas's case, Liechtenstein regulations, or what kind of regulations that be, to really come down to a proper legal conclusion. In today's class, we're going to kind of step over the last step. This is kind of the nitty-gritty part. I think it's too complex for today's discussion. We're going to focus on the policy consideration side, and then on the roles, and discuss those different roles in one particular example to make the discussion a bit more lively and easier to understand, which is going to be a DEX. I think most of you are going to already know how the concept of DEX is, so you can or should be able to align on that. From a step 1, the DeFi policy consideration approach. The way this has been decided on this slide now, I think there are obviously different means how you can build a toolkit for policy considerations. Here we distinguish between 4 key policy consideration, which we identified as being important in that space. First policy considerations to look at is this anti-terrorism, money laundering policies and sanction regime. So basically, all types of policies in most jurisdictions around the globe are quite harmonized on that, or many of them are, which address fighting criminal conduct, fighting terrorism, kind of keeping the financial system clean of illicit behavior in that regard. Mostly that's being addressed in sanction, embargo regulations, it's being addressed in AML regulations, so you're probably all fairly familiar with that concept. A second very important policy consideration to look at are financial market policies. So essentially kind of policies guaranteeing the stability of financial markets as such. Mostly those are being expressed in Financial Institution, Financial Services Acts, and in tendency they apply whenever we have something called financial products. I think in our discussion today, we can keep in mind a bit, it's not always accurate, but that these become relevant whenever they have securities or the financial products which are relevant. The third category we want to look at is consumer protection policies, so kind of regulations that aim at really protecting consumers. It's a lot about banking regulations, a lot about unfair competition regulations, also has some element in financial infrastructure laws, but whenever we have a need to protect consumers from illicit behavior, from possible technological failures, those policy considerations come into play. And the last one, of course, tax, VAT, we just heard a lot about that in the last session. How does the government assure that people participating in those setups are properly taxed? And so maybe by way of example, to illustrate a bit how this policy framework can be applied, the logic is that we look at a project and say, hey, on those 4 levels, what is the risk category we put that in? Is that not relevant at all because we don't see any risk at all that consumers can get harmed, or is it more relevant? And if we look at maybe 2 recent or relatively recent enforcement cases, probably most of you know, is one of them is Tornado Cash, the sanction against this Tornado Cash smart contract. Basically, who doesn't know what Tornado Cash was? Yeah, so basically, just in a nutshell, Tornado Cash is a decentralized application allowing the hiding of transaction streams on the blockchain, so kind of a tumbler, essentially. And what happened back then, without moving into very much these details, that it has been sanctioned by the US, that everybody interacting with those smart contract addresses, that has been prohibited, in a nutshell. And if you look at from a policy consideration perspective, yes, of course, by hiding transaction trails, you potentially can facilitate money laundering. And effectively, what happened in real life, that there was evidence that a substantial amount of digital assets have been laundered through that process, and that was money that has been hacked by a hacking group from North Korea. So if you look at the policy considerations, yes, we have money laundering considerations. We have proof that North Korea, which is subject to embargoes from the US, and criminal activity from there has been used in that tool. And so the risk factor obviously is high, which essentially led to those sanctions of Tornado Cash. Another example we can quickly look at is the OkiDAO case. OkiDAO, essentially a DeFi protocol allowing the trading of leveraged products and derivatives, which has been structured as a DAO to kind of avoid kind of regulatory impact, and which then has been got into focus of an enforcement case by the Federal Trade Commission in the US. And here again, we have a lot of financial policy, market policy consideration to make. We have a classical, more or less classical financial product, which is highly regulated, moving into a decentralized, unregulated space. And so this has a high potential to be subject to enforcement measures, or at least come in the radar of regulators. This by way of example. The example we want to use today is the one of a DEX. And just to remind ourselves quickly how DEX operate, and I'm very well aware this is a very kind of an illustration which makes things a bit easier as they actually are. But to understand, we have essentially in the middle, we have the DEX, decentralized exchange smart contracts. Normally, we have different trading pools, which are being illustrated by those 2 boxes. And we have two parties interacting with them. We have the general users doing exchanges over the DEX, and we have the liquidity provider providing liquidity into mostly two pools within the DEX. They may or may not use a web interface for that. So most DEXs have a front end or multiple front ends being operated, but most trades will go directly through an API in the back end in a general sense. And what kind of roles do we have in that DEX? We have, of course, someone developing a DEX, so someone coding how the smart contract shall work. We have someone deploying the code, putting in on-chain. We have possibilities front-end operators allowing an easier access to the DEX infrastructure. We have the user using that for their own purposes to trade assets. And we have the liquidity providers, which essentially put in funds, allowing others to trade on them and receiving a yield on those trades. And then quite often we're going to have token holders related to the DEX as well. And I think it does make sense now in today's conversation that we look out at those individual roles and do a risk assessment of these. To kind of shorten, because we have limited time, I think, unless you disagree, I think the general concept for developers now is that only developing code without having any further interaction with that code, without deploying, without doing anything else, that's not per se a regulated activity. So if you agree, we can skip that and move on to someone actually in the role of developing and deploying the code of a DEX to see what risk elements we have. If we now take the DEX and move back and look at those 4 elements of policy considerations which we can make, anti-terrorism, money laundering policies, what do you guys think? Ronnie, is that something relevant in a DEX? Is it of a high risk or mid risk? What would you say?
Yes, I mean, of course. I mean, I think it's a question that has not been answered yet, whether from a regulator's perspective, but also not from a legal doctrine. I mean, at the end, what are you doing on a DEX? I mean, one person is going to the DEX with the intention of exchanging digital assets, and another person is providing liquidity into a pool with the aim of getting a reward by offering liquidity. If you look at it from a pure economic perspective, of course, you can say, I mean, what's the difference between money exchange? If you go to the airport and the money exchange office is just exchanging money. I mean, that's one view. But of course, the other view is also that you first of all have to think about, I mean, what is exchange? So an exchange of utility token is irrelevant from an AML perspective. And then, of course, you can also argue and say, I mean, how connected is the transaction actually between one of maybe 1,000 persons in a liquidity pool with the person actually exchanging? Is this still a business relationship or not? Or is it that disconnected that you have to say it has nothing to do anymore with a traditional understanding of money exchange? So that's why I see the AML part as something very relevant for DEXs.
I see it slightly different. And my take it is, I see the exchange side of things, and we'll get there as well. But from a purely AML perspective, can I really launder money on a DEX? Does that really work? And there, I must say, if you look at how it works, I can only interact with my wallet with a DEX, so I can't really use a DEX to transfer funds in an anonymous way to a third party without that transaction being fully visible, because I always interact with my own wallet. Even as a liquidity provider, I put in funds and take the funds back to the same wallet I put it in, essentially, otherwise, unless I transfer the LP token. But if I transfer the LP token, this transaction is also visible on chain. So I think it's a challenge to launder really effectively money on a DEX. That would be my view on things. Thomas, do you have a...
Actually, I mean, this is one way, and most DEXs operate that way. You can actually also operate a decentralized order book, right? Which has a lot of challenges when it comes to speed and cost. But your argument is basically that even if you send something and you get something else out of it, it's always via the same address because you self-custody, you use your own wallet, right? I do understand your argument, but to be very honest, I'm not a compliance expert. So
no, I mean we don't need to solve that. Essentially, I think we can say from a policy consideration, DEX probably is somewhere around medium, low, AML risk, medium. From a financial market protection perspective, I think it depends whether we're going to have securities on the DEX. Yes or no. If there are securities, obviously we do have considerations to make there. If we don't have securities only from a Swiss view, utility and or payment token, then the financial market protection considerations are probably not as relevant. From a consumer protection policy perspective, I think, there is, of course, the risk, I would say, that smart contracts are not safe enough. There may be a risk for the consumers, especially for the liquidity providers who rely that those smart contracts are not hackable. But otherwise, it is mostly sufficiently decentralized that the standard kind of banking law, do we keep deposits from third parties, probably don't apply that much. That would be my take. Any other thoughts on that?
Yeah, I would say I agree, but of course it also depends then on how much control the deployer or the developer still have. So whether they still have owner or master keys, and then whether or what they still can do with them.
Yeah.
But otherwise I agree. I mean, it's then like autonomous.
Okay, very much agree. And Thomas, from a tax perspective, now looking at the role of someone deploying a DEX, is there particular tax considerations this individual or group needs to make?
Yeah, I think as we discussed in the panel before, it's always relevant to know who are the counterparties that are involved in a certain transaction, just to evaluate your own tax liability or maybe the tax liability of someone else. And what we know is there is a user, we know there are liquidity providers, but the uncertain part is the kind of the smart contract DEX part, where assets are held, where usually also some rewards are generated. And the question there is, where are these assets and these rewards allocated for tax purposes? So you could argue, as long as, again, whether some deployer has, as long as he has certain control over the assets that are held in the smart contract system and the rewards that are generated there, that such income and wealth could be allocated to such deployer or any other party that is involved in the transaction.
I mean, what I can add here is the Liechtenstein perspective when it comes to the deployment, right? So even if you do the deployment for a third party and you get paid for it, that's for us, that's a registration. So you need a registration for that based on the local regulation we have in Liechtenstein. When it comes to MiCA, that is not part of the scope. So this pure deployment part is not covered.
Okay. Well, let's stay a moment with the deployer. So, a question, Guido. Yes.
The problem with an old world of a bank or not a bank, but with an exchange, do we not have a problem that, at least according to the regulatory perspective, we have either a centralized exchange, we have full control, so I have to fulfill all the financial market licenses and the requirement, or I give away black and white, I give away total the control, so the full decentralization, then at least I need not a license, but how is the regulatory fitting to these cases in between, where I have at least a certain control over my DEX and marketplaces, but on the other hand, I have not the control if there's a security token or not a security token, or if there's a KYC or not KYC requirements provided by the single transaction. So
we'll get that. Be a bit more patient, and if you have not been satisfied, ask the question again, please. All right. So, but essentially, what Guido's point is, it is actually the issue we need to look at. If you look at the deployment, so solely deployment, I understand from your input, this itself does not necessarily trigger the regulations, but it depends what additional role you take in that DEX. And one role you can take, do you have control over the protocol? So do you have any control over the smart contracts, how that operates? Do you have control over certain parameters within a set framework? Do you have factual control? So basically, like in the UKIDAO case, there is something like a decentralized governance body, but factually you control that governance body either because you have sufficient token to control that, or because just factually nobody votes, and with 2% votes you can change anything in the DEX. So one view how to look at that from a level of control perspective, of course, if you have no control over the DEX at all, even though if you deployed it and you don't generate any fees, so additional topics we'll need to cover, then you probably sufficiently decentralize on the control level. Now, my question to you guys is essentially, now moving away from this no control at all and moving in this gray zone there is to a certain level of control, what is your take? And let's start with just the mere questions on upgradability of a smart contract.
One question. So you wanted to keep it simple. So okay. Otherwise, because to challenge the first analysis, actually, if you use hash time lock contracts, so atomic swaps, and you have involved two protocols, and you interact with a set of smart contracts, I would actually exchange my token A, run on layer 1 on a specific layer 1A, and then I will get token B from a layer B, fully automized on a set of smart contracts, and then I actually could launder money. But I don't want to make it too complex. But there could be a way how to launder money.
There could be a way.
Yeah.
Yes.
So.
You want to answer the question?
That's your part.
So the question was about upgradability of smart contracts, and I think if you want to be on the safe side, and that's my opinion, then you have to deploy a new version, which means that the old one is still existing. People still can use, but maybe then you will not support it anymore with your user interface. Where I see a way which you could also do, but it is a little bit more risk, is if you still control some parameters. For example, if you can adjust the deployed smart contracts in a way that you can add new key pairs or new standards, but you cannot interfere with any transactions, so you cannot stop, reverse, or do anything else. I mean, that I would say that's likely still possible. That would be my opinion. Yeah.
Funnily, the Swiss VAT authorities, in one case, they concluded as long as you cannot prove that someone else is in control, then you as a developer and deployer are considered to be the controller, even you don't have any factual control. So they kind of turn it in a way that say, you need to prove it's someone else. You have deployed it. Now it's running, so now you're the operator, and only if you prove to us that someone else is the operator and has control over the assets, then we kind of accept that that has been transferred out of your control area. But otherwise, we consider this to be still the activity of the deployer and the developer. Okay. But it's very weird view from my
So basically, attack logic would be, well, whoever deploys is an operator as default, and if you don't prove otherwise that someone else is, you have to have an operator, and then you're liable on the tax side. I think from a regulatory perspective, that does not work. Here you need to kind of show that someone is the operator from a regulatory perspective, and that's the whole exercise we're trying to avoid. But your statement is, well, even if you manage to do that from a regulatory level, that doesn't necessarily help on the tax side.
It's just the view of the tax authorities, so...
But is it the developer, the deployer, or the copyright holder actually the one that contributed to the code?
Good, in that case, it was the same entity. Okay. So developing and deploying and financing the protocol.
Okay, good. Another always very, sorry, question? No? Okay. Another topic which is always a big discussion with clients we have, well, can we make money? Can we take a share of all the transactions fees arising out of our DEX or the DEX we deploy? And again, obviously, looking at it from a decentralization perspective and kind of the risk to avoid to have this operational role, as long as you don't take any fees, you don't take any cut of transaction fees, then you have a much better argument. That is clear. But then the question is, well, how bad is it if we start taking fees? Is that something which is an absolute no-go, or is that a certain way to maneuver in between? Thomas, do you have any thoughts on that from your end?
I think it's quite the same in Liechtenstein with the control and also with if you take fees, right? That's a very strong signal for the regulator that they have someone who is in control and someone who is actually making profit out of it, right? So they do that for a commercial purpose.
So I would see it likely a bit different, and I don't think so that the fees itself then will result into being regulated, because I'm looking more from an ICT perspective, where basically the DEX is like a decentralized software as a service, which is operated on a decentralized infrastructure, and basically the fees, I would deem them like as a usage fee. Or if you look at the licensing regime of software, it would be like a license fee and not really as a fee for the transaction itself, because the transaction fee is usually then not directly related to what is flowing out of the DEX. But of course, that's for me a critical aspect on how this correlates with the actual transactions. I don't know, Thomas, you maybe from tax, I'm always wondering whether you also see it as license.
Yes, certainly. So if you get fees, the question is why. So there need to be a reason why you get fees. So it can be because you're the IP holder. It can be because you are providing work or services to the DEX, or it can be because you're operating and intermediating transactions, and that's why you're involved. But I think the fees as such are not decisive, so it's always the purpose why you get it then related with the other kind of control questions we have discussed, in my view. So mere just receiving fees, at least certainly from a tax point of view, you're taxable on the fees, yes.
Yeah. And how you do that? I mean, VAT on a DEX, how you know who is your counterparty?
Yeah, then you come back to the questions this morning. So you don't know. And then you need to come to certain conclusions or agreements with the tax authorities how to evaluate the kind of the user base of your DEX in a way where then the fees are generated from. Or you argue that the DEX is always a foreign kind of entity that is operated outside of Switzerland. So I always kind of deal with someone that is outside of Switzerland, and that's why all the services and licenses that are rendered to that party would be exempt from Swiss VAT. So it's the same discussion as we had this morning with mining and staking. So you don't know, but you should know, because otherwise the risk, again, they just flip it and say if you cannot prove it, then it's just 100% in Switzerland, so we charge 7.7 on all the term.
What I normally see in those setups is that as soon as you have fee, you want to have control over the parameter defining the amount of the fee. So I think this concept of having no control, but you do have certain direct revenue streams, it's probably rather a rare animal to see. You mostly find then a certain level of control plus the fees, which in an overall perspective, in my view, kind of raises certain red flags on a regulatory level. Yes?
On the revenue sharing, what are your thoughts on designing governance tokens, tokenomics of governance tokens, to allow some sort of revenue sharing, direct or indirect, to the token holders? And do you see any way of doing that without obviously just being considered a security token or just moving revenue sharing, right, revenue sharing towards any entity that's operating in X, but then, of course, there's the possibility to funnel the revenue more towards the token holders, and these might be more distributed.
Well, I can try to start with an answer. I think certainly when you issue a governance token with the clear, giving the expectation that at some point you're going to get revenues on your governance token, which is no longer a governance token, then you're in this security discussion, in my view. I think the setup is discussion may end up a bit differently if that role, the functionality of the token related to the DEX in a fully decentralized concept changes through the governance which you have not influenced. So the issuer originally never raised this expectation. There was never a topic. It was not on the table at all. The control was handed over to some form of a DAO, and the DAO decided to kind of amend the contract without involvement of the issuer. Maybe things look a bit different there. That would be my view.
Yeah, I mean, I agree. I think if it's a pure revenue sharing token, I think then we don't have to discuss that. Likely most regulators will see it as a security because they use an economic perspective. But if the reward is linked to individual contribution to the DAO or to the whole ecosystem, I think then there is an argument to get out of being qualified as a security.
Good. Let's look at another role. Let's look at the front end. Sorry? Another question. Apologies.
Sort of a follow-up on that. As you're referring to the Swiss classification as security payment utility token, obviously in the US, the regulatory landscape is a bit different. As these projects are global, does that situation in the US impact any of these decisions when you're thinking about security payment utility classifications here?
As soon as there is a US Connex, which mostly is, yes, of course. I think it's probably hard to set up a project like that without involvement of US regulatory expertise.
Yeah, okay, so then there's no clear answer for how, if it's a utility token by a Swiss classification, how you manage that with any US interaction, which is almost impossible to avoid.
I mean, you can only manage it on an issuance level, because there you can also exclude the US if you want, and also do further measures to not allow US persons to participate. But I think everything that happens on a secondary market level, you cannot control. And I also know, I mean, there are US experts that say secondary market is still your responsibility, others say no. I think there you just have to take a risk approach.
Okay, so let's move on to another role, the front-end operator. There's always like a big discussion point. Can we operate the front end? What additional risk does it create for us if we, to our DEX in this example, but also to other DeFi protocols, operate a front end and provide easy access to that? Maybe just to share the Swiss regulatory view up front on that. So providing a front end depends a bit what kind of DEX, what kind of digital assets are being traded on the DEX. So the logic there is that as soon as we have trading pairs with security token or asset token under now Swiss law, then providing the front end is deemed to be seen kind of like a financial infrastructure service. Because we are, remember in this slide, we are then in these financial market policies. So you would actually need an appropriate license for that. As long as the trading pairs that you have or make visible on your front end, so that are not necessarily the same ones which the DEX actually operates with, but the ones you make visible and easily accessible through the front end are on the utility and payment token, that doesn't really trigger the same concerns from financial market policy considerations, so you not necessarily regulated because you provide that front end. Is that understanding is similar in Liechtenstein?
Yeah. Yes, it is very similar. We do have the definition of MiFID, what a financial instrument is, and for us it's also substance over form. And as soon as you touch that area, you have all of the existing rules in place. And if you display these trading pairs with securities, there is a lot of regulation to be considered. If it's non-securities, we do have even the framework we have in place in Liechtenstein is not covering that. When it comes to the upcoming MiCA, that's subject to another analysis actually, because there are some market abuse rules. There is investment advice, which is a rule. So I'm looking forward to get some answers there. We don't have them yet. But that's going to be an interesting one, because what we already have seen is like these bulletin boards, which would be actually in theory exempted, even when it comes to securities. But in practice, we had cases in Liechtenstein where finally it was a licensable event, Anlagevermittlung, which basically triggered then the licenses. So that is a very interesting area, and it depends. I think it adds a lot of complexity for now, as soon as you have trading pairs with securities.
Yeah, same here. I think the interesting question in all is, well, what is if I just provide a front end? If I'm not related to the DEX at all, I have not been involved in development, not in the deployment, I don't provide liquidity, I'm operating one of many multiple front ends, which, quite often everybody can do that. Does that change anything?
In my opinion, yes. I mean, the more traffic on the DEX that is generated outside of your own front end, the more you have a proof that it's really decentralized. And I think a very beautiful way to do it is also that you just publish the front end open source and then leave it up to the community to run a front end and also to adjust this front end. Because if it's really just only for making the DEX graphically visible, I think then you also do not own money out of that, so you can also leave it up to the community.
You said a very crucial, you pointed to a very crucial fact. If you allow the community or everybody to list trading pairs there, because if you pre-select, the question is if this is already investment advice, because you pre-select trading pairs, you say like, this is a good, this is a bad investment, right? So,
yeah.
Maybe also from a tax point of view, there's a consideration that, or the question is, the user, does he assume that he buys the service from you? And there is kind of case law with hairdressers and kind of certain service providers at Langstrasse in the red light district. So the question is, if you have a hairdresser salon, but there are a lot of kind of independent hairdresser, who is providing the service? Is it each individual, or is it everyone together as because there is a website and there is a kind of only one door where you can get in, etc. And there are certain decisions where they say it's actually, so there are different parties and you assume to go to the hairdresser with one website and that's your service provider. Whether he then buys that service from each individual that is actually providing the service is irrelevant, and you look just at the public kind of offering. And if you look at the front end, if I go there and say you can buy or swap Ether to whatever, and I do it, they could argue, I assume that I buy it from there, and that because I pay it, I interact at least on a certain level with that website, and actually the infrastructure in the back end, I don't really care, right?
Mm-hmm. Okay. Always a bit tricky with that VIT. Good. Well, for me, it is this question about multiple front ends is a lot about also creating dependencies, and I think that's one of the design elements we need to keep in mind, that as soon as you create dependency from the user, a regulator is likely to say, hey, you're actually operating because the user is dependent on you. So if you're kind of the front end, and most not crypto savvy users don't know how to use a DEX at all, but they certainly don't know how to access DEX through like an API, so they're dependent on the front end. And if you only have one front end, you do create this dependency, and so the likelihood that the DEX is going to be attributed to you is much higher, which kind of makes a lot of sense. Looking at the time a bit, I think the last role I would like to discuss is the liquidity provision. So this is mostly not someone related to the development, deployment, the front end as such, just providing liquidity into a DEX. And interestingly enough, while we now could conclude, and as long that you can even operate a front end to a DEX as long as the trading pairs you list on your front end don't qualify as security token, and at least from a Liechtenstein and Swiss perspective, US may be different. You're outside, still could be outside regulations. The Swiss view is if you provide liquidity to the DEX, you're likely to kind of, or possibly fall into a regulated category. And that again depends on what type of liquidity, what type of digital assets you provide. If you provide liquidity in security tokens, you're likely to qualify as a security market maker, which needs a license. If you do that in payment token, you likely qualify as an AML regulated exchange. On utility token, you're outside regulations. So this is currently the concept how that would be addressed. And maybe first question to Liechtenstein, what's the view? Is there a view? And if yes, what is it in that regard?
I think I would have to make up my mind first, because I did not prepare that slide. And what is your understanding? Because I would have to go through, because we had cases with liquidity providers, but they were outside of Liechtenstein. We had the interface and the DEX part. So yeah, I don't feel comfortable in answering that.
Fair enough.
Sorry.
Yeah, I mean, I see it a bit the same. I mean, with security tokens, I think it's obvious then you becoming a market maker because you're providing constant liquidity. With other payment tokens, I mean, we are back at the topic at the beginning where I'm not sure if unfortunately, but likely it is the case that you offer the exchange of money. And of course, then the question is whether you do that on a professional basis or not. So likely most of the retail non-professional participants will be outside of regulation. Then of course, it also depends on your jurisdiction. But I think these are the key questions for liquidity providers. And in particular, if you are a financial institution and if you want to participate in a DEX, it likely gets a bit more complicated. And that's why I think most of the financial institutions, at least in Switzerland, are not really participating in DEXs.
From a tax perspective, have you ever kind of considered the service of a liquidity provider, how that's being treated from a VAT particular perspective?
Yeah, at the end you provide liquidity, and usually you get certain like interest or reward on it, right? So most probably it would be considered a financial service. And as we learned this morning, financial services, that's one advantage, is exempt. So if you would provide liquidity and get fees from there, that would not trigger VAT liability. But certainly it's taxable income as any income as you generate. The question again is it actually only you as a separate person kind of providing you liquidity and getting interest, or do you act together with all the other liquidity providers and actually you're considered like a simple partnership providing together liquidity that could then trigger additional liabilities in other jurisdictions?
Okay, thank you. Well, I see we almost there. I think we probably need to end soon, right? So to wrap up a bit, I think we covered quite a bit on design topics, and maybe this slide helps you again to understand what we look at when we help designing decentralized protocols, DeFi applications, as a default basis, avoiding any the most possible risk, avoid controlling things, avoid ongoing contractual relationships, so don't keep in custody assets, don't provide your own custody solution, even on a non-custodial basis, avoid direct revenues, and avoid creating dependencies of the users of the DeFi protocols. And whenever as part of the design process, deviations are necessary, then it makes sense to really discuss it in detail and look at the general risk framework of the application of the protocol, and to see what the actual impact on the legal and regulatory and tax level is. I think we probably do have time for a few last questions. Yes.
One of the earlier questions was, where is there a possibility of money laundering? Of those particular roles, is it the liquidity provider where there's a possibility that there's more chances there? You were going through the different roles. What's the experience that you've seen possibly? Is it harder to nail that one down? Is there a more obvious one of those roles which come into play? I mean, we killed a few of those few, but what about the liquidity provider? What's the risk of your choice of liquidity providers?
Well, I think one discussion point, obviously, I mean, the liquidity provider could transfer, let's say, illicit funds into a pool. I think that is clear. And so basically, but he would need to take back those funds again. So you don't really delete the history per se. Of course, and Thomas is right, there are more complex transactions possible, which you then could use to launder money. One approach is a bit, especially on the institutional side, when kind of considering interacting with DEXs, to whitelist those pools, or at least do a proper chain analysis on a tool to know what is the risk rate on the AML side of a particular pool. Great. Any other questions? Yeah.
I was wondering whether any of you have any thoughts on regulation. So for background, we were discussing different roles here, kind of stumbling upon the issue that we have traditional financial market laws that don't really fit to the actual roles these people or entities or whatever take. So, and you present kind of design factors and how we can limit risk. So do you have any thoughts on putting that into a self-regulatory regime for the DeFi industry per se, to kind of make that more legit or more general, or do you have any thoughts on that?
Yeah, well, I have some thought, but I'd be happy to kind of share that with the audience. You want to start?
I mean, not from a Swiss perspective, but in general, I think if you wait for a regulator to regulate your area, you risk that they will start to regulate when they have bad cases, and that always normally triggers bad laws. So it's better to start with like a code of conduct, self-regulation. The question is if it's sufficient to have a self-regulating organization, then an SRO, and if this is sustainable, or if you need policymakers and lawmakers to come up with a regime. So I think it's better now in 2023. I think it's better to start somewhere, right, to avoid really bad cases and to be able to provide at least some answers for now.
And I think one to add on that, I think, you know, the different ways how you could tackle that, and possibly even self-regulation would then have an influence on the final policy and regulatory decisions. But I think, you know, having proper audits of the smart contracts is already something. So having kind of clear standards on what is a smart contract audit, how it is being conducted. And the other one would be the example we just gave, kind of providing some kind of indication on transactions that have been done with a pool to know what is the AML risk level of that. So how many addresses have interacted which popped up on a chain analysis tool as being of a certain level of risk. Yes, please.
Hi, thank you. Roshi Sharma from Morgan, I'm a lawyer in London. The principles that you've discussed, the design decisions, were applicable to Switzerland and Liechtenstein. But as soon as you go outside those jurisdictions, do you need to consider principles that won't work for the UK or Hong Kong, United States, right? You kind of need to work it out country by country. Is that right? Or
Yeah, essentially, that's what I tried to kind of say at the beginning. We normally work in 3 steps. So like the policy considerations, or those ones, they're more or less global from a policy perspective. So most jurisdictions have concepts in their regulations protecting those interests in some form. And so when you know, hey, do we have a project which kind of tangle those policy considerations, then at some point you need to move down to a country by country local regulation level and say, hey, how has it been implemented, and do we actually trigger local jurisdiction in the first place? Yes.
Before this discussion, I thought my understanding as a non-professional, non-expert on the topic was the token holder, the voting rights holder was the risky role there. Most of the time in DAO is fairly centralized, the power, and then it's unregistered, so they can do lots of damages. But based on this discussion, you focused your attention to other roles. So what's your thought on this?
Yeah, you're right. No, you're not wrong. A token holder has a role, depending on the project, of course, and this role can be decisive. For time matters, we kind of jumped over that, but I think you wanted to have it on the list, Ronnie, so maybe you can give a...
I think the token holders could be a 1 or 2 days workshop, because it very much depends on how you structure it. I mean, is it a DAO? And then if it's a DAO, I mean, a DAO at the end is a decentralized governing system. So the question is, what is the DAO doing? Is it organized in a legal form or not? What are people actually doing? Do they have rights to vote over a treasury? Do they just have other rights? So it very much depends, and I think it's very complex, and we are still at the stage where it's not 100% clear on how to deal with DAOs. I mean, they exist, they are here. And of course, it's always also a question of the individual token holder, what you risk when you participate in a vote. So what I can tell you is I recently done a research with a project in multiple countries, which was including Switzerland, US, Spain, and I think Portugal and Estonia. And everyone came to the conclusion that as an individual token holder, if you not control a majority, the risk of being liable for a decision is rather low, except in terms of sanctions, because in sanctions law, there you, in most cases, you're going to be liable just for acting with negligence.
And remember maybe the example on the UKI-DAO I gave at the very beginning. There, the focus of those enforcement measures is not against any token holder, but essentially it is against the DAO, but in focus will be the few participants who control that DAO. That's
Quick question, I think. Is there a way to have a DAO legally recognized within Switzerland? Can you register a DAO as a legal entity?
well, you can structure a DAO as a legal entity. I think that will probably be the right term to use. So you would kind of use an existing legal structure, like an association, for example, and structure the DAO within that framework. Yes. Yeah, I think we need to cut. Apologies for taking away 10 minutes of your lunch break. I hope you enjoyed the conversation. We're still going to be here, so if any questions arise, please feel free to approach. Thank you.
Fantastic. No, thank you.